Today we are looking at the organization of political power in the United States of America. The first question we have to ask is, what type of political entity is America? When we think of America, we tend to think of it in terms of a country, and of course that is not wrong. However, it is not 100% correct either. In fact, America does not really exist. What does exist is the United States of America, made up of two distinct power sources. The first, the federal state, was created by the US Federal Constitution, which established a president, the houses of Congress, and the US Supreme Court. But inside America, there are also 50 states, and each of these states also has their own constitution, their own executive power, their own parliament, their own courts, and their own legal system. In fact, the majority of law in the United States actually comes from the states and not from the federal government. From a legal point of view, America is not so much a country, but a collection of 50 entities or states, all bound by the common thread of the values underpinning US democracy, as laid out in the US Federal Constitution. Once inside this 50-state union, there are two mechanisms at play. The first is free movement of people, goods, and services. For example, once a product is legally produced inside one US state, it can then move freely to the other 49 states. The second mechanism is the existence of a common currency, the US dollar. The next question we have to ask is, how do the federal and state powers work together? Prior to answering this question, it is perhaps important to remember that it was the states that created the federal government and not the federal government that created the states. Thus, the role of federal law might not be as prevalent as we might first think. When looking at this issue, we have in fact to ask two questions. The first is, how does the federal power interact with the 50 different state powers? The second is, how do the 50 different state powers interact with each other? So how does the federal power work with the states? Federal power and state power coexist on the basis of two simple principles. The first principle is that the federal government is a government of limited or enumerated powers. This means that the federal jurisdiction is limited to those areas in which it is expressly given power by Article 1(8) of the US Constitution. Moreover, pursuant to the 10th Amendment, those powers not expressly given to the federal government are expressly reserved to the states. The second principle is that federal law is supreme over state law. Although federal law is restricted, in the areas where it does apply, according to Article 6 of the US Constitution, it takes supremacy over state law. Next, we have to see how the different 50 state powers interact with each other. States in a free trade area such as the United States have a choice between two basic mechanisms when choosing how to govern relations between them. They can either operate on the basis of harmonization of regulatory rules, or alternatively, under the principle of mutual recognition. Let's take a closer look at these two mechanisms. Under the system of harmonization of regulatory rules, states will adopt the same rules governing activities between them. Thus, they will have the same harmonized rules governing the production of goods, the offering of services, the same rules in education, financial services, etc. It will be a harmonized regulatory zone, as indeed is the case in most countries. The alternative is the application of the principle of mutual recognition. Under the system of mutual recognition, each state will adopt its own rules, but agrees to recognize goods and services coming from other states produced under different regulatory rules. In such a system, the regulatory system of each state is forced to compete with the different regulatory systems in the other states. When faced with this choice, the US chose the mutual recognition model. Thus, there is regulatory competition between the different 50 US states, and like in every competition, there are winners and losers. The winners tend to be those states that specialize in a particular activity. For example, rich states like California have specialized in the information technology industry and cinema. The state of Delaware has specialized in the area of company formation, and the state of Nevada in the area of gambling and entertainment. Less successful states, such as Mississippi, have traditionally failed to successfully specialize in this way. So that you can better understand the issue of regulatory competition, Part 5 of Chapter 4 discusses the principle in greater detail. We hope you have enjoyed this introduction to the organization of political power in America.